Kudos to our hosts in having two Matthews as your guests and selecting a case where the plaintiff's name is Matthew, Matthew Preston. That's impressive.
Three Matthews. Yeah, all right. Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant.
If you've been enjoying Water Cooler Justice, take a moment to follow us, leave a rating, or send your favorite episode to a friend. We really appreciate the support. Today, we're joined by two highly respected lawyers in employment and labor law, Matthew Fisher and Matthew Certosimo. Matthew Fisher is an employment lawyer and partner at Lecker & Associates in Toronto. He has over 15 years of experience and some landmark cases under his belt. Matthew specializes in wrongful dismissal, constructive dismissal, and severance negotiation. Matthew, thank you for joining us.
Thank you.
Matthew Certosimo is an Eklund Award-winning lawyer representing employers in labor and employment-related litigation, including wrongful dismissals and labor arbitration. He frequently appears before the courts, including at the appellate level. Matthew is the co-author of Just Cause, the Law of Summary Dismissal in Canada, which is frequently cited in decisions. Matthew, welcome to the show, and thank you for joining us.
Pleasure. Thank you for having me.
Okay, today we're going to talk about two cases, Preston v. Cervus Equipment Corporation and Bertsch v. Datastealth. The common theme in these cases is that employment law may not be as unfair to employers as it is often alleged. It's rather a heavily technical process. Both of these cases show that the devil is in the details. Sarah?
So let's dive into the first case, Preston versus Cervus. So this is an interesting case, which seems to have established a relatively unique or new precedent regarding release provisions in settlement agreements, specifically how these provisions apply to vested stock units post-termination. So we'll take a look at the facts. Mr. Preston was employed by Cervus from 2014 to 2018. Cervus enticed Mr. Preston away from his former employer by granting him $25,000 in stock units, which vested immediately upon his first day of employment. Now, Preston also participated in the company's deferred share plan, which allowed him to apply up to $20,000 of his annual bonus towards the purchase of stock units, which would vest immediately. Furthermore, the employee opted into the plan, and Cervus would match those purchases with additional stock units that would vest over a 3-year period. Finally, the plan stated that upon termination, the vested stock units would automatically be redeemed and the unvested units would be canceled. Upon termination, Mr. Preston was presented with a severance package. However, he decided to commence litigation against Cervus for wrongful dismissal. It's important to note here that the claim did not actually contain any reference to or any specific claim for the vested stock units. And at the time of his termination, Mr. Preston had over $75,000 in vested stock. The wrongful dismissal action was ultimately settled for just over $100,000, less deductions, and both parties agreed and signed the settlement agreement shortly thereafter. Now, when Mr. Preston requested payment for his vested stock units, Cervus took the position that Mr. Preston had actually released these units when he signed the settlement agreement. So Mr. Preston went ahead and commenced litigation against Cervus. The motion judge awarded Preston $75,000. However, this judgment was ultimately set aside by the Court of Appeal. Chris, what are your thoughts?
The first thing is, there was a summary judgment motion to recover the vested stock. And this is stock that he either was given as an inducement to leave his job or that he purchased with his own compensation. These are the vested shares, right? The summary judgment at the summary judgment motion, the motion judge agreed and awarded the stock. And this employer went the distance. They went all the way up to the Ontario Court of Appeal, and they were successful on what I thought were some pretty technical grounds. Maybe I'll turn it over to Matthew Certosimo to start us off with some thoughts about from a management perspective, because I know you've got a lot of management clients, Matthew.
Well, kudos to our hosts for the foresight in having two Matthews as your guests and selecting a case where the plaintiff's name is Matthew, Matthew Preston. That's impressive.
Three
Uh,
Matthews. Yeah, all right.
but also kudos for pairing these two cases. I know we're talking about first of all the Matthew Preston case, but the two of them you talked at the outset about the devil in the details theme. I might add just a few other themes and then circle back to your specific question. First of all, it struck me in reading these two cases that it reminds us of the proper role of the courts in the interpretation of contracts. You know, a deal's a deal's a deal, with apologies to Gertrude Stein. And you know, it's not the role of a judge or the courts, as the Court of Appeal noted in the Preston case, to rewrite the bargain between the parties because you feel, for example, in this case, that the economics of it didn't make sense to you as a judge. Secondly, there's this ongoing we see this in these cases, Waxdale, et cetera, this tension between contract and statute, but also, in Preston, contract as in the settlement agreement and other agreements between the parties, such as, plan documents, stock option plan documents, or it could be benefits, it could be an LTD plan, as Matthew and I recently experienced in a case. These interplays and these tensions create some interesting challenges for parties, and this case illustrates that. And thirdly, there's an underlying theme in both of these cases for the lawyers who are watching your program about the role of counsel. You know, there's a reference to ILA in both cases. You know, there's an issue of drafting, there's an issue of negotiating, there's an issue of litigating, there's an issue of timing, all involving the role of counsel. And that led me to conclude after reading them again, there, but by the grace of God, go any of us in practice, right? Whether it's the one who drafted the agreement or the settlement documents or what have you. So I want to stop there because I think I should allow my friend to jump in. But I think when you look at those themes and you come back to the bottom line of Preston, the Court of Appeal said, look, this is clear language. The parties entered into a clear language deal, and it's not for the motions court judge to rewrite it.
Matthew Fisher.
The practice theme that it always reminds me of, I've always found there's this point at the end of a mediation when it's been too long, it's been too difficult, you've been at this for years, very frustrating, you've come to a number. And I especially remember early in my career when we were sitting in some tower in Bay Street, they said, hurry up, it's just a minute, let's get them done. And I remember thinking, no, I've spent the last 3 months or 3 years on this. We have put all this work in, and none of it will matter if the decimal is in the wrong place or the release has 2 extra words that we didn't notice. This is all that matters at this point because it's exactly what the judge says. I don't care what you talked about all the time. I don't care what you sue. You have a piece of paper. It says this. You signed it. That's the end of it. It gives me great confidence that I remember having very early on when I told the media, tell them I'll get back to them when I get back to them, and someone else can pick up their kids. And I don't care if we're settled because we're not until we sign. You know, even today, it, reiterates the notion of a checklist before you finish settlement. Do you have these things? Were these issues covered? Whether it's a disability issue, whether it's a savings plan issue, stop just focusing on is it the right number of months? Is there everything else that we haven't talked about because we thought we agreed upon? That's what I look at as far as the practice. When I look at the decision itself, I mean, it's easy and nice for lawyers to look at other ones and say, well, if I was there, I would have done this or I would have done that. It was a very challenging case, an unfortunate case for the plaintiff. But one thing that stood out to me specifically is, Chris, I agree with you, it was immensely technical, as these cases often are when they get to a court hearing. But the Court of Appeal made the specific comment that Mr. Preston did not submit that the settlement was invalid or that there was a unilateral mistake.
Yeah.
That stood out to me because I joke that I'm an employment lawyer and a unilateral mistake lawyer because I once defended and won at the Court of Appeal a unilateral mistake case called Kearns and Canadian Tire. And that was all about, we'd signed a settlement and mediation that couldn't have been clearer. And the employer said, oh, there were things we didn't realize when we signed that, like how much money we paid him already when he didn't sign the original settlement. I said, that's nice. I'm sorry to hear that. And we had to take that matter all the way up to the Court of Appeal. But the unilateral mistake analysis, I think it could have come to a different outcome in this case, because especially the fact that he emailed before and said, "Can I have it?" And they said, "Send us the signed settlement documents." To me, if he had made the argument, again, I'm armchair quarterbacking here, but if he'd made the argument that he didn't know it was a unilateral mistake, they snapped it up, they took advantage of it, they knew full well what they were doing, and they waited after he signed it and said, "Ha, guess what we just did?" That the court very well at least could have had something to grapple with that's a little less technical about whether there should be rectification.
That jumped out at me as well, Matthew, and maybe because I too litigated to the Court of Appeal a mistake case and succeeded on rectification for a plaintiff. Vic Hepburn was my client, and for 10 years we fought for enforcement of his CERP in the face of
10 years.
10 years in the face of some, well, there was a CCAA in the middle, and we had to get
Oh,
around the CCAA on the argument that the monies in the CERP were subject to trust, and therefore we, like a pension plan, could get around the CCAA and proceed with the
that's awesome.
case.
That's great.
Won at trial in front of Justice John Murray shortly after his appointment to the bench, and then succeeded at the Court of Appeal. But Murray's decision is really worthwhile reading in this context because it may be one of the leading rectification judgments out there. He takes a long time to take you through what is the proper analysis of mistake leading to rectification. And we succeeded. And that was a tension case between the CERP and the severance deal, the golden parachute. And you're right, Matthew. In light of the facts, what were they? Well, there was the letter that went to the employee at the time of termination saying, go ahead and exercise your vested stock. There was the wrongful dismissal that didn't have the options as a subject matter of the claim. There was the email that you referenced, all leading to the question, was there a mistake made? And was it, and it would have to be mutual in my view to succeed. And was it a mutual mistake, which ultimately one party was able to take advantage of? And you're right, Matthew, query whether there would have been a different outcome if he had been able to succeed on that kind of an argument.
I have two more questions about this case that I want to hear your feedback on. The first is that the Court of Appeal placed a lot of emphasis on the specific language relating to the equity compensation. And so part A of my question is, have your forms of release become longer with more specific language in them? So part B of my question is, have you had instances where plaintiff's counsel has said, well, it looks like we have a deal in principle, but we need a carve out for the DPSP, the deferred profit sharing plan, or we need a carve out for, the vested shares, or we need
We're both smiling because we just did that. We just did that recently, a carve out for something.
Because I'm having a hell of a time having large employers move on their standard form release.
Well, I do find this, it's an increasingly frustrating issue, to a certain extent, because, and I just had this correspondence with a lawyer who said, okay, we can make, you asked for 3 changes to the minutes, Matthew, no problem, but my client will not change its standard form release. And I felt like saying, I'm sorry, is that LLB or is that just a blank spot after your name? Like, you're asking some person with no law degree to say, well, the form is the form, and all they can do the form. And most lawyers have never read the full release. They don't understand it. They don't know what's in it. We'll settle a complaint where, 25% of it is a human rights complaint. And then the release will say, I have never had any human rights complaint. And instead of saying, I hereby release by this payment. I think we need a reform amongst the whole employment law bar to move to a shorter English language release that people will read and understand. It covers what it needs to and doesn't cover 17 things that it doesn't. Because, to a certain extent, I'm sure everyone a little bit glosses over, some of these enormous paragraphs. And I think it stood out to all of us. Part of the big problem for the plaintiff in this case is it's specifically listed amongst the kitchen sink items there. It specifically listed this. And I'm sure that the plaintiff's lawyer, at least I would in the circumstance, the first thing I'd run back to and say, was this just a general release that released everything, or did it specifically address that? And I think that probably, or clearly it assisted and would assist the court in saying, well, it's specifically in there. It's not, it's up to the lawyers to read it, to review it, and the clients to address it. which is easy when you're sitting on the bench and to say in hindsight. But I think that created a huge challenge. But I guess the problem, and Matt, you could comment, but I imagine what then happens with employers, they say, let's take this, or their counsel, let's take this 7-page release we have. Now there's one case, let's make it a 8-page release or a 9-page. Every time there's a different case that comes out, and simple cases end up having massive releases to them, which I'm not sure we're doing anyone a service. I think it would be better either to treat it as part of the settlement where the lawyer actually crafts the release for it, or have some simpler wording that we use, rather than this long document that everyone's afraid to make any changes to.
Yeah, I think going back to the theme of the role of counsel, your point is an excellent one, Matthew. We as lawyers have a role to play in ensuring that the documents reflect the deal. And that means going beyond boilerplate. But that's more than just the opinion of this guy. That's really what was going on in the Preston case. John Callahan was an excellent, extremely experienced litigator before he was appointed to the bench. The motions court judge applied the Supreme Court of Canada and Corner Brook. The essence of that logic was, well, we have to be careful in interpreting the scope of releases because everybody uses, broadly worded boilerplate language. The problem with that logic in this case was that you had a rather specific phrased deal in the Preston case, which the Court of Appeal noted took us where we needed to go to enforce the deal rather than fear misinterpretation of boilerplate language, which leads me to say, and this is, I think, your point, Matthew, we need to be careful in the drafting of the deal. Easier said than done, of course, but we need to be careful in drafting. And what I would point out with respect to and I mean that with respect to the employer counsel in the Preston case, is the use of very careful language that ultimately the Court of Appeal was able to say did in fact cover the stock option plan. I mean, think about some of the language. Let me quote a couple of lines to you. Settle all matters earned and or claimed, including all matters and entitlements earned or claimed, raised or that could have been raised in the action, but more specifically in the release. Expressly, the releasor, the employee, expressly declare no entitlement to bonus, share award, stock option, or deferred share. Like, to me, those are the magic words that somebody thought about in the context of settling the deal. And the scope of the deal from the employer's perspective in that regard quite reasonably could have included the 76 grand that would have covered the payment out of the stock option units. We don't know for sure, but they could reasonably have included that in their math of the 100K that ultimately was part of the settlement.
It would be interesting to know if that was part of their boilerplate release or the opposite, if they put that into this, because that would fit into the unilateral mistake issue.
Right.
If I were in examinations for this, my question would be, show me all your other releases. Show me that take out the personal details, but show me the last 10 wrongful dismissal settlements you have.
I have one follow-up question, and I think it's yes or no, counsel. Would you give a carve-out in your employer client's form of release for vested shares if it was requested?
Well, if you're asking me as employer counsel, the answer is no, but I would think that it depends is the official answer to all difficult questions. But as a general proposition, I would say no. What I would rather do is include the topic as a matter of the negotiated settlement. What's the bargain we're working out here? The delta was between the offered severance package and whatever he landed at in the end. That would have been the delta in terms of the negotiations. But the starting point presumably would have been the 75K plus the offered severance package. What I would have wanted to see is clarity, particularly if I was on for the plaintiff, clarity about that floor being the place that the negotiations started and the inclusion of the 75, 76K in options in the ultimate outcome.
Right. It just would have become part of the negotiation if it was raised right?
Exactly. Now, what Matthew was referring to is a different kind of case where, shall I say, there was a third party involved. And
okay.
that third party carve out would be a reasonable one. And that takes us back to the Corner Brook case, because it was a third party claim that the case involved. Was the third party claim covered by the release or not covered by the release? And the Supreme Court of Canada ultimately agreed with the motions court judge in that case and said it was covered by the release. So a carve out of the third party claim would have been necessary to protect the interests involved. So if there's a third party claim involved, a carve out is probably a wise thing to do.
All right, I think that's good. Sarah, why don't you take us through to the end of this case, and then let's move on to Datastealth to take a look at another instance of employer success.
Of course. So the court's decision here, the Court of Appeal sided with the employer, Cervus Equipment Corporation, in determining that Mr. Preston effectively waived his right to the $75,000 in vested stock units when he signed the settlement agreement. And they went further in the costs discussion, and they ordered Mr. Preston to pay $30,000 to the defendants. Correct me if I'm wrong, but I think this essentially nets him around $0 based off of the original settlement.
Yeah, loss on every metric.
Yeah.
Can I just jump in there, Chris? There's one of the
Sure,
things.
please.
There's an ominous final statement by the Court of Appeal near the end of the judgment, and it's one that we should all just think about. I'm quoting: "We offer no comment regarding other legal remedies potentially available to the plaintiff."
Yeah, I think one of the themes here today is that employment law is technical, and it's not for the faint at heart, and it's not for the inexperienced. Many of the decisions, some really important decisions, are not reported, they're not readily available, they don't come up on a CANLI search, and if you don't know what you're doing, you can cost your client a lot of money, right? I don't think that's what happened here. I want to be really clear about that. But employment law is very, very technical. I note that piece in Preston. I cite it to opposing counsel when I'm looking for changes in the minutes or changes in the release. And if I don't get them, then we don't have a deal. And it's become a real problem. I've seen some matters which should have settled in 3 months, 4 months, 5 months, take 12 months. And that, justice delayed, justice denied, right? So is this a helpful case to the bar generally? I don't know, but it certainly it puts its finger on a point. And I think Matthew Fisher's comment about a standardized release is interesting. And I think also your comments, Matt, are super timely in the sense that we're counsel, right? Like it's our job to do this work on both sides too. If you need to make changes to the standard form documents that your client is accustomed to using, make the changes, get the deal, move on, right? If you're uncomfortable, in making changes, that's a problem because it's going to become a barrier to settlement. And in an employment matter, if you push someone to trial, the closer they get to trial, the more likely they are to want the full amount of the claim. The best resolution is often an early resolution for all parties. Timeliness for the plaintiff, a lower cost for the employer in many instances. So those are my thoughts. But let's move on to Datastealth, which I also thought was another interesting case.
Yes, another significant case as well. So in this case, the termination clause of an employment agreement was upheld by the Superior Court. And as we know, this is a fairly rare occurrence. I guess the threshold is relatively high. And this case serves as reinforcement that a well-drafted termination clause, which limits entitlements to statutory minimums, are in fact enforceable. So we'll dive into the facts. Gavin Bertsch, the plaintiff, in this case was terminated after only 8.5 months of employment with the defendant Datastealth Incorporated. Upon termination, he was given 4 weeks of pay in lieu of notice, which is actually higher than the 1 week's pay he would have been entitled to under Section 57A of the ESA. Bertsch's claim asserts that the contract terms, which limit his compensation at common law, are not enforceable because they are ambiguous and fail to properly reference the ESA. Additionally, he argues that the termination clauses are invalid because they allow for dismissal without notice, even in cases where the employee did not engage in serious misconduct. And on the basis of the contractual limitations are invalid, the plaintiff claims 12 months' pay in lieu of notice, i.e. about $300,000. So let's discuss the enforceability of termination clauses. Would one of the Matthews like to jump in first?
This case, it's a funny case because the level of excitement on the management sidebar on LinkedIn was through the roof. We won something, we won something. And I didn't want to be mean to anyone involved and say, any of us can take, once in a while you do get an enforceable termination clause. It is technically possible. We could all draft one, and I appreciate when they're not drafted that way. Because then we have something substantive to argue about. In this case, they didn't. This case was, with all due respect to everyone involved, was wrong from day one. At least from what they put in the decision. I'd be interested to see the rest of the contract, because often these days the breach is not necessarily right there in a termination clause. It can be somewhere else. This was, I don't know that this was some special win for employers as their counsel would like to suggest, or some swing from the court. It is that once in a while there are enforceable agreements, and you want to write a demand letter and see if the employer knows that. By all means, try. But if you get a skilled management side lawyer on the other side who tells you it's enforceable and they're right, your retainer should probably end at that point, and you move on. It's interesting that they brought this, I believe it was a Rule 21 motion, which was somewhat rare, but I mean, again, a smart move for the management side lawyers, right? I'm right. I know I'm right. This is clear. We don't need any facts. I don't care what you think or feel about it. I'm just going to bring this to the court. To me, there's not much to it other than the answer to the question. Yes, enforceable termination clauses do exist. So if they do, try not to litigate them. The arguments themselves, I mean, it was, as I understood the argument was that the employer didn't specifically enumerate when an employee was terminated for willful misconduct or willful neglect of duty that has not been condoned, that wasn't spelled out. Agreed, it wasn't. Again, and I'm sure the court sort of struggled. I wasn't there, but I imagine the judge's comments were something to the effect of, yes, and hopefully your argument is coming up after that. Again, congratulations to the management side. I don't think it changes anything. It's a reminder, if employees had the sense, or any counsel had the sense that there's no such thing as an enforceable contract. There certainly is. It's just, one has to be careful in figuring out which one goes in column A and which one goes in column B, especially before you stand in a courtroom.
From my perspective, this case is and I don't want to overstate it to your point, Matthew, but this case is the long lost offspring of Mactinger and Hodge. Remember, Iacobucci wrote, "The year I started with Borden and Elliott, 1992, the floor can be the ceiling." And ever since, we've had this attempt to get around that basic logic. The floor can be the ceiling. Of course, the floor can be the ceiling if that's what the parties agree to. It can't go below the floor. The Act says that. The Supreme Court of Canada and Mactinger and Hodge said that. It seemed pretty obvious, but in any event, kudos to Howard Levitt for winning Mactinger and Hodge in 1992.
Wow, shout out to Howard. All right.
Yeah, and it's taken us all this time to get a case to state what essentially was what that leading case stands for. So the question then becomes, what do you have to do to turn the floor into the ceiling? And to your point, Matthew, this whole domino thing that ultimately led to Waxdale and maybe Render, started with the very point you just made. Somebody didn't mention benefits in an employment contract, and so it was implied. It must have been intended, therefore, that the employer was trying to get around continuing benefits in accordance with the Employment Standards Act, or continuing to pay their premiums in accordance with the Employment Standards Act. Well, that to me is ridiculous. Employment contracts should not be interpreted as silence intending non-compliance with a statute. That is what we have here. We have a judge who, by the way, was on the bench for 6 months when he released this Rule 21 motions court decision. An experienced litigator who basically said, yeah, they didn't mention, as Matthew said, they didn't mention the definition of the exemption to having to pay termination and severance pay that's in the regulations. So what? That doesn't mean they intended to breach it.
In fairness, I mean, what the provision actually says is you understand and agree that, comma, in accordance with the ESA, comma, there are circumstances in which you would have no entitlement to notice of termination, etc. So, I mean, it actually says right in the provision, in accordance with the ESA. So I think that that's probably sufficient to sort of clarify what the circumstances are.
Well,
For
and,
me,
and if you go a step back in that same section, it says with or without cause, you're going to get the ESA.
right.
In fairness, the people who drafted this employment agreement with that language, they thought about it.
Yeah, I don't love with or without cause. I would, in my form of termination provision, I just deal with you get the entitlements. Because I always feel like those words are kind of loaded words now. Like you might end up with you might have to bring another Rule 21 motion to get rid of a plaintiff, right? So yeah, I try not to put any try not to wave the red cape in front of anybody so that I get the charging bull, as it were. But what I'm more interested in here is there was a secondary argument that the termination provision wrongly denied the plaintiff a right to benefits. And of course, 3 months later, another case came out, which was, I think, Ramatar and Trader Corp, which said that, if the benefit provision during the statutory notice period is left up to the insurer's policy or the insurer's decision, then the provision is void because the Act provides for payment of the employer's contribution premiums or the employer's premiums to the employee in the event that the coverage doesn't continue. And so, I wonder, like, even this provision, may now no longer be enforceable, or this form of agreement may no longer be enforceable, but the benefits section isn't in the decision, so I can't really see.
If I'm looking here when they have the contract terms, it does say and benefit continuation.
Yes.
So I think that's, I think, as I say, the problem here is if it was the mission of an experienced employment lawyer to say, Mactinger's old, I want something new. I want to have the new Mactinger and have my name out there. So I'm going to argue the case where the floor and the ceiling are not good law anymore. I want to argue that there has to be consideration, that giving somebody their statutory minimums is not consideration. Then that very experienced employment lawyer should gear up to eventually go to the Supreme Court, gear up their client and get ready. But that's not what happened here. That was, that's a different argument for a different day. The problem with making those arguments, again, as we've done here, they can be dismissed so simply, it doesn't deal with benefit. Yes, it does. It typically says there. There'll be benefit continuance, and it uses, wide enough and narrow enough language. It's not the contract to try and change the law, and it's certainly not the contract to try and, use the language. I respectfully disagree with my friend, the other Matthew here, about the various technical exceptions that we've come up with over the years. Because I always look at it from the perspective that a 40-year employee who works for a $2.4 million employer and is terminated and signed a contract last year where he got a Tim Hortons card in consideration for a binding ESA clause and gets his 8 weeks, is being taken advantage of. And that anything the law can do to equalize between that $2.499999 million employer and the individual who has no idea what he's signing in exchange for the Tim Hortons gift card because he doesn't know what the Employment Standards Act of Ontario and the rights and entitlements therein and your notice and severance in accordance with said act, no concept of what it is. If the employer managed to mess up the benefit language or managed to mess up any part of it, and they retain a proper plaintiff side employment lawyer who finds it, then they should get out of it. The employer, I think it was Justice Lowe who made the comment, I'm trying to remember the case, but she said it's not that hard to draft an enforceable clause, and if you can't, employer, with your HR departments and your management side employment lawyer on Bay Street, I don't have sympathy for you. Just do it right. I do think that there is what we may call technical arguments. They're important and they're there to level the playing field somewhat. And I certainly try to take advantage of every single one I can find, because the default really should be common law, and the 8 weeks for 40 years should be an exception, not a rule for anyone who signs whatever's put in front of them.
We had another guest on recently who said that if the default was common law, and if employers and prospective employers actually knew that they'd have to pay common law to everyone, that it would be a financial disaster for the province of Ontario.
Yeah, sure. Thanks. I've heard that. I've heard a company say, well, then if I have to pay this, we should move to the States. Okay, move to the States.
Well, but remember I know what you're saying, Matthew, and I There's an element of what you say that I don't disagree with, but let's go back to the other case, the Matthew Preston case. I mean, one of the points that the Court of Appeal was making was it's not up to the courts to consider those economic considerations, economic factors in their sense of a good deal versus a bad deal in interpreting the contract. Their job as a court is to interpret the contract. In the case of Datastealth decision, you have a logical, well-reasoned decision that came to the conclusion on the face of the very clear language that there's no ambiguity and no breach, real or imagined, of the Employment Standards Act. So we're going to enforce the deal. And that would have been the right outcome, whether the employee was 40 years service or what was this? This is long enough to get a cup of coffee, I think. 8.5 months, right? You know, whether it was an 8.5 month employee or a 40-year employee, the judgment, in my view, in the Datastealth case was correct because the language was so clear.
And if there wasn't sufficient consideration, that's a different argument.
A different
Yes.
argument, and you probably should take into account the entirety of the bargain and not just the subset of the contract found in the termination clause.
That was great. I think that's a great place. We've brought it all the way back home, right? And I kind of agree with where you're coming from. Like, words have meaning. But I also hear where Matthew's coming from. There is an imbalance between the parties. There's a desire to do justice. I think judges want to do justice. I think people want to see justice done in their courts. It's hard for me to look at Preston and feel like that's a correct outcome. Because the inducement money went into those vested shares. He left his old job to join for those shares. The other shares that were vested, he purchased with his compensation. He was allowed to use up to 20% of his compensation to purchase those shares. That's a tough pill, I think, to swallow. Does that feel right? Does that feel just? Right? And I can get my head around the arguments and I can get my head around the language. But at the end of the day, that's a tough pill to swallow. Maybe, the last thing I'll say is to Matthew's point, about walking away when the provision is clearly enforceable, $6,000 in costs for the plaintiff here, right? So they had to pay to be wrong. They had to pay their own counsel, and then they had to pay employer's counsel for the privilege of taking a run at that thing. And so that's worth thinking about, when you're advising your clients or when you're thinking about, is this the contract to gear up for the Supreme Court of Canada, as Matthew said. So Sarah, I'll turn it back over to you for a moment.
Yes, so we'll take a look at the court's final decision. So essentially the court found that the termination provision was clear and unambiguous, concluding that it did not contravene the ESA or its regulations. The court emphasized that there was no reasonable alternative interpretation of the relevant clauses that might result in an illegal outcome. So consequently, the court upheld the termination provision as enforceable and dismissed Bertsch's claim for common law notice.
I think this is a great place for us to stop today. We're about at the end of our hour that we usually like to sort of hold our episodes to. I hope you'll both come back and join us again. I think this was a great conversation. And I learned a ton, actually. I had read these cases, and I learned a lot today, and so I want to thank you both. Sarah, thanks for keeping us on track. To our listeners, thanks for tuning in. If you like this episode, again, please subscribe or leave a review. If you have a case you'd like us to discuss, or if you'd like to share your own story of workplace drama, and we love workplace drama around here, email us at watercoolerjustice@gmail.com. Until the next time,